Hey guys, my name's Austin Stringham. I'm with Red Rock Real Estate. Today we're going to be going over the real estate purchase contract and what that looks like when you're putting in an offer on a house. So at this point, we're going to assume you're pre-approved, you found your house, you are ready to make an offer. Let's look at the contract and why you would want to use this contract versus trying to do it yourself unrepresented. Why you want to use this contract is because it protects you. It covers everything of any mishaps that might happen if the seller destroys the property, hurts the property, natural disaster happens. It outlines everything that you need to know in order to make a successful offer and get your house purchased. So let's start. Today is the 23rd of September, 2023. Here's your name. Buyer's name goes here. Seller's name goes there. You would deliver an earnest deposit amount of $5,000. The numbers don't really matter here. And in the form of cash, you can wire it. You can do it by check. However, so offer to purchase. This is in section 1. You're outlaying the property that you're planning on buying, address, tax ID. That's how you know you got the specific property correct. And the included items. So any of the fixtures, anything installed into the house is generally considered a fixture. Window coverings, curtains, draperies, rods, window blinds, all that kind of stuff. Is generally included in the sale of the home unless it's otherwise outlined that it's not. Other included items, let's say if I'm representing the buyer, we're going to try to get as much as possible on the initial offer and wait for the counter offer to come back to see what the seller counters at. So we click washer, dryer, refrigerator, microwaves, other, and then for this example, I just put living room and TV stand. So anything that you might want to include in the purchase of the house, we can put that in the contract. It's all negotiable. Okay, section 2, the purchase price. So for this example, we're saying the purchase price is $400,000. And right there, section 2.1, A, B, C, and D, and E, all those numbers at the end of the day need to equate to the purchase price total. So we got our earnest money deposit of $5,000, no additional earnest money deposit. We're getting a new loan of $381,000. So that's going to cover if it's an FHA loan, typically 3.5%. That's $19,000. So we'd have the earnest money deposit that goes towards your purchase price, plus the $14,000 you're going to have to deliver at settlement, and then the bank will deliver the rest of the money, $381,000 at settlement to the seller, and that will get all the funds tied up. Sale of the property 2.2. If this is your first home, if it's your first home, you don't have another property that you need to sell in order to buy this home. But there's all these different addendums and contingencies. That's why if you're wanting to make an offer on a house, use a good agent, and everything on the real estate purchase contract will cover your needs in order to get the house in a way that makes sense for you. Section 3, 3.1, settlement. That's where the buyer and their party and the seller and their party representatives are meeting together and exchanging all the signed documents. All that's being done, and then all the money that the buyer is required to pay the seller, not part of the loan, but the buyer's $14,000 will then be paid to the seller. Possession, that's where you actually get the keys to the house. If I'm representing you, the buyer gets possession upon recording. Pretty simple. Prorations, that's just anything due, but let's just say taxes weren't paid by the seller. They would pay that, and that would be credited towards the buyer at settlement. And just simple prorations like taxes, homeowner association dues, rents, all that kind of stuff. All that stuff, whatever needs to be paid, that will be delivered to the buyer as a credit so that they can be paid off, and all that stuff is taken care of. Escrow fees, that all that will come down. Buyer and seller will have their respective fees paid, rental deposits and prepaid rents. So any prepaid rent that is, if the place that you're buying is rented out, let's say, or a room is rented out for a certain amount of time, all of that will be prorated and credited towards the buyer. And HOA, if you're buying in an HOA, sometimes they have transfer fees that are associated with that, and that's all negotiable. In this offer, we can see that the seller would be paying that transfer fee of the HOA. Utility services, sales proceeds without holding. Buyer agrees to be responsible for all utilities and services provided by the property after settlement. And sales proceeds, the escrow closing office is authorized and directed to withhold from seller proceeds at close sufficient funds to pay off on the seller's behalf all mortgages, trust deeds, judgments, mechanics liens, any liens that are on the property, any clouds on the title, that will be taken from the seller's funds that are coming in from you, and that'll all be paid off. So Section 5 is just confirming the agency that has already been established. That's a separate document. You will, with me, you're never going to sign a seller or a buyer broker agreement until we make an offer. If any agent is making you sign a buyer broker agreement, some of them might be worth it because they might not work as hard for you until they know that you're committed to them. For me, I'm working, it burns some time because not everyone that works with me wants to sign the agreement. But when we're ready to make an offer, we'll sign that buyer broker agreement and we'll get this offer submitted to the seller, the seller's agent, I should say. Section 6.1b, short-term rental bookings. Buyer agrees to accept title to the property subject to any short-term rental bookings, meaning for the period of less than 30 consecutive days affecting the property not expiring prior to closing. The provisions of 6.1b shall survive closing. So if there's any short-term rentals and you're accepting that in the middle of that short-term rental, you're going to be paid for that. Title insurance, you always get title insurance in case there's any encumbrances on the title. The title insurance will take care of that. So if you don't have title insurance and someone claims that they have an ownership to that property, that can lead to problems. That's why you just get title insurance, and so that you can rest easy that the property you bought is going to be yours and the insurance company will fight for it. Seller disclosures, that's any issues with the property, any encumbrances on the title that they know of, any issues with the property in general that the seller knows of has to be disclosed, and that's usually due 2 weeks after they accept the offer. Due diligence, you always condition your offer on due diligence. That basically gives you the right to cancel the contract before the due diligence deadline, basically for any reason. If you don't like the way something smells, if you don't like anything, that's what this period is for. And you always do it on due diligence. You always go through your due diligence. And in another video, we'll go over the full due diligence checklist that covers anything that you want to be aware of before purchasing the property. Now, if you're getting a loan, appraisal condition, it is required that you get an appraisal because the bank is not going to loan you more money than the property is worth. So, and if you're buying cash, you might want to do appraisal condition too. If the appraisal comes out to less than what your offer is, that allows you to revise the offer and only pay for what the appraisal comes out to. But some people don't really care. I put in an offer a month ago that the buyer did not care. It wasn't conditioned upon appraisal. He was willing to pay cash for it based upon his own opinion of the house. Financing condition, section 8.3b. So if this is your first house, obviously you're probably going to need financing unless you got plenty of cash. And you have the right to cancel before, if you don't get approved for that loan, we'll make sure that we put in the offer so that you have the right to, even if it's after due diligence, even if you don't get approved for the loan after due diligence, we put right here, you get all your earnest money back. Buyer doesn't get to keep any of it. Now, when they counteroffer, that might change. But when we go in on the first offer, we're always going to do, if you need financing, it's required, or if you can't get the financing, none of your money is going to be lost if you have to pull out because you didn't get the financing you thought. But that shouldn't really be a problem if you're pre-approved. So you really shouldn't have to worry about that. If you're pre-approved, you're going to know exactly how much you can afford and how much roughly your payment's going to be, and you're going to know all that before you put in the offer. Additional earnest money deposit. No, we're not going to give them an additional earnest money. That just, obviously, if we're in a market where sellers are having so many offers, then maybe you'd change that to make your offer more attractive. Addenda, that's just additional terms and conditions that the REPC may not cover. There's a lot of addenda that will cover those terms and conditions specific to your transaction. So for this one, it's a common one. We're doing an FHA loan, so that will be covered in the addenda. And if you don't have that, then maybe there's no addenda, but there usually is one or two. Buyer home warranty plan. That's really up to you. If the seller's paying for it, then you might as well take it. And this, if we submit an offer, we're going to just try to get the seller to cover the home warranty. Again, if it's seller's market and they're getting a lot of offers, maybe you wouldn't even talk about that, because if you're competing with other offers, then getting that offer accepted becomes a little more challenging. So condition of the property. The property should be in the same condition that the buyer saw when they submitted the offer and was accepted. There are rare cases that I've heard of. I've never seen it, but I was watching Ben Mala on YouTube, and he was reacting to some TikToks, and they had a nightmare where the old owner wouldn't have moved out. So that's where you want to do your final pre-settlement walkthrough. If you do your walkthrough and it's not in the same condition, you can back out. Changes during the transaction. No substantial changes or alterations to the property should be made while the property is under contract. Financial encumbrances, changes to legal title. No further financial encumbrances on the property shall be made, so the seller can't take out a loan on their house, like a HELOC loan, while they're under contract, obviously. No other existing changes to property management can be made. Long-term lease or rental agreements, that can't be broken under contract while it's under contract, unless everyone agrees to it. Short-term rental bookings. Short-term rental bookings. If the property is made available for short-term rental booking during contract, seller may not, after the seller disclosure deadline, continue to accept short-term rental bookings. So they can't, after seller disclosure deadline, they can't accept any more rental bookings. That would breach a contract. So authority assigners. So if there's like an LLC that owns the property that you're trying to acquire, they can appoint someone that signs on behalf of all the buyers. Complete contract. So the REPC, together with all the addenda, any attached other documents, seller disclosures, constitutes the entire contract between the parties and supersedes and replaces any and all prior negotiations, representations, warranties, understandings, or contracts between parties, whether verbal or otherwise. That's basically saying, the REPC is like the supreme law of the land. It's basically the constitution of the transaction. Everything in the REPC outlined in the complete contract overrules anything and is the contract. So it's very important that everything's how you want it to be, so that no disputes are made between buyer and seller. Mediation. Any issues, so if someone defaults on the contract, we're going to always say should be resort to mediation before you go through trial, or you don't want a party to sue each other. So you want to mediate, and if that fails, well, then it might move on to a lawsuit, and you really would rather avoid that. Okay, default. If buyer defaults, seller may elect one of the following remedies: cancel the REPC and retain the earnest money. So that means you lose your earnest money deposit as liquidated damages. They can they can give back the earnest money, and they can sue you. So you would definitely, when you enter the REPC, it's important that you and your realtor stay on top of those dates and make sure if you want to back out for any reason, you need to either back out before the due diligence deadline or submit an addendum for an extension of that deadline well before it goes bad. If seller defaults, buyer may elect one of the following remedies: cancel the REPC, and in addition to the earnest money deposit or deposits, if buyer may elect to accept from seller as liquidated damages a sum equal to the earnest money deposits, or maintain the earnest money deposit in trust and sue the seller specifically to enforce the REPC, or accept a return of the earnest money deposits and pursue other remedies available at law. So in this contract, you would have to go through mediation before you can file a lawsuit. In the event of litigation or binding arbitration arising out of the transaction contemplated by the REPC, the prevailing party shall be entitled to the costs and reasonable attorney's fees. However, the attorney's fees shall not be awarded in participation to mediation under Section 15. This contract shall be governed and by and construed in accordance with the laws of the state of Utah. The provisions of this contract of this Section 17 shall survive closing. So again, that basically goes back to all the fees and stuff will be covered. So if the seller defaults and you try to mediate and then you go through a lawsuit and you win, then the seller has to cover all those costs as liquidated damages. So no assignment. If you're the buyer, you can't assign the REPC to someone else without consent of the seller unless you're part of that, like a family partnership, trust, LLC, partnership, or corporation. So you can't assign that REPC to someone else. So just make sure you want to make the offer. Okay, this is if anything happens to the property. As of closing, buyers shall be responsible to obtain casualty and liability insurance coverage on the property in the amounts acceptable to buyer and buyer's lender, if applicable. And then if prior to closing, any part of the property is damaged or destroyed by fire, vandalism, flood, earthquake, or act of God, the risk of loss or damage shall be borne by the seller, provided, however, that if the cost of repairing such loss or damage would exceed 10% of the purchase price referred to in Section 2, either seller or buyer may elect to cancel the REPC by providing written notice to the other party, in which instance the earnest money deposit or deposit, if applicable, shall be returned by buyer. So basically, if the house burns down or something while it's under contract, you obviously don't have to buy that house. And hopefully the seller has insurance on that. I'm sure they do. Time is of the essence. That just means all the days and everything means something. So you need to do your due diligence by the due diligence deadline. Inspections, hazards, radon, all that kind of stuff, lead paint, inspection, all that kind of stuff. All that needs to be done by due diligence deadline, and any extensions need to be agreed by in writing. Okay, guys, and this is the last page. Electronic transmission and counterparts. The REPC may be executed in counterpart. Signatures of any documents, whether executed physically or electronically, shall be deemed original signatures, and they have the same effect. So you can do things electronically. It's all done electronically through email and stuff of that sort. Acceptance only occurs when and all the following have occurred. Seller or buyer has signed the offer and counteroffer where noted to indicate acceptance, and seller or buyer or their agent has communicated to the other party that the party's agent and the offer or counteroffer has been signed as required. Pretty self-explanatory. And then here's all your dates with respect to the original acceptance date. And that's it, guys. So that's your REPC. If this is what it looks like to make an offer here in the state of Utah, if you use an agent, this is the document they're going to use, or one that's made by an attorney, but oftentimes it's this document, and it's good to know it as the buyer. It's good to just go over it and be familiar with it when you make an offer so that you know what to look for and what bases are covered. If you guys have any questions, please contact me. My information is in the description, and I really appreciate you watching. And you can always call, text, email me, or leave a comment. I'll get back to all of them, and I really appreciate you guys watching. Hopefully I covered everything today, and hopefully you guys got something from this. Hey, thank you so much. Have a great day.